First, Mr. Gee died from sudden cardiac death, brought on by his long-standing and uncontrolled hypertension and acute cocaine toxicity. Nothing the plaintiffs have said this morning, and not one shred of evidence, suggests that low-level CTE, which he was diagnosed with by the BU Center, causes hypertension. No evidence. Second point, this case is about 88 to 92. I'll walk you through the limiting instruction, but the judge even told you there's some reasons you can consider things that happened after 1992, but not relative to whether the NCAA acted reasonably between 1988 and 1992. All of that stuff afterwards can only be considered by you for a special purpose. So I just want to remind you that again, and we'll walk through that. Third, I want to walk you through the NCAA's role, which you heard plaintiffs' counsel denigrate and make fun of. But the fact of the matter is, the schools got together, who existed before the NCAA, and started an association. The NCAA is a sports association. It's not a medical body. Plaintiffs would have you believe we had a higher burden than their own doctors who they came in here, who they brought in here to testify as experts, and the entire medical community. The entire medical community. They want to hold us to a higher standard. That is not the definition of reasonableness. We'll talk more about that. And the NCAA's actual role and the things it actually did. And then you get to decide whether those things were reasonable or not. We, of course, suggest they weren't. And the fourth thing we'll talk about is that there is nothing the NCAA could have done that would have changed the unfortunate and tragic end of Mr. Gee's life. Nothing.